The early Supreme Court didn't have a whole lot of power. It didn't actually exercise judicial review for some time. So it wasn't seen as a major player in the battles over who was going to have power in the federal government. Was it going to be the executive or the Congress? It also didn't play a large role initially in battles between the federal government and the state governments, questions about federalism. It just didn't have a lot of power, and no one took that power, which is important because later people are going to take that power. But nobody took that power, and it was a kind of, it stunk as a job, actually. It was not a pleasant job. There were not a lot of inferior court officers, and so the Supreme Court justices had to do what was called ride circuit. Riding circuit sounds innocuous enough, but it was terrible. They had to ride on horses, in horse and buggies, on terrible roads, in terrible weather, long distances around the country to hear cases. They would stay in terrible, flea-bitten places. I mean, they wrote letters home saying how awful it was in the heat, in the cold, in all kinds of conditions, not in their own homes, traveling around, hearing these cases, and it was terrible. I mean, in fact, there were moments where the president who nominates Supreme Court justices couldn't find people to become Supreme Court justices, right? Nobody wanted to do the job. Now, I don't say nobody, but nobody who was potentially qualified, who the president was trying to get to take the job. They didn't want to do it. It was not a good job.
Most of the justices on the early Supreme Court didn't stay for very long. In many cases, left to become justices on their state Supreme Courts, which were at that point more powerful than the United States Supreme Court. They had jurisdiction over more issues. You'd rather be on the highest court of New York, for example, than you would be on the United States Supreme Court. They left to become diplomats, like John Jay did. They left to go into private practice. Partly this is because the Supreme Court didn't have very much power yet. And partly it's because circuit riding was really quite miserable.
The early Supreme Court didn't have much to do. There wasn't the vast body of federal law that we have today, and it wasn't entirely clear that this was an important job. Some people turned the job down because they had better things to do with their time than sit on this court that didn't have much to do. There were some important cases decided in the early years, but it was only when John Marshall became Chief Justice that the Supreme Court began to become the potent force in American life that we know today.
So part of it is that as I said, they just didn't have jurisdiction over all that many kinds of questions at that point. And part of it is that today we think of judges as these individuals for whom we have a great deal of veneration. Often, I think we have far too much veneration for our judges. But that was not yet the case then, right? So you have this institution that I think it's Hamilton's famous formulation, has neither force nor will, but only judgment. That's what the court was at that point, and any attempt to push the boundaries of sort of the political consensus or any attempt to push back against important political actors, the court is likely to lose. So essentially, there's not that much important business coming to them, and what there is, they're hesitant to be too sort of proactive or aggressive about.